like Mr. Azultine, I may be pronouncing that wrong, is had a fairly recent warrant. I would, if we're comfortable addressing that on the record.
Yep, Mr. Azultine, are you able to turn on your microphone?
Can you hear me now?
Yes, sir. Okay, it looks like you missed your hearing on July 16th, just a few days ago.
I am, without recourse, sui juris, in propria persona, the living man, and not representing the incorporated Ty Warren Azultine entity. I am the affiant of the affidavit of truth filed in this case, April 26th, appearing specially and not generally under threat, duress, and coercion to correct the mistaken identity misnomer of the defendant, and notice this court to dismiss this case sui sponte for failure of joinder, failure to serve the complaint, failure to state a claim upon which relief can be granted, and lack of jurisdiction.
Welcome back to another wild day in court. Today's hearing features not one, but two sovereign citizens, both convinced that the laws of the United States somehow don't apply to them. And if you've ever watched one of these courtroom standoffs, you know it about to be an absolute train wreck. We got Mr. Azultine, who refuses to acknowledge his own legal name, and later Mr. Matthews, who thinks court jurisdiction is a matter of personal belief. But here's the twist. What starts as a simple warrant and a traffic citation quickly spirals into a bizarre philosophical meltdown, full of pseudo-legal gibberish and comedic defiance.
And I have some questions before I feel comfortable with this court moving forward. Has someone entered a plea on behalf of the defendant?
All right, I'm not going to be able to address this case unless I have assurances that the defendant, Ty Azultine, is the person here. And I'm hearing a lot of nonsense that doesn't address directly, that rather obfuscates the clarity on who you are. If you're not Ty Azultine, then you're a spectator and you're welcome to stay. If you are Ty Azultine, I'll address your warrant, but I will address no other issues in this hearing because this hearing is limited to quashing warrants and setting court dates. So are you Ty Azultine?
Does the caption of this case not say Ty Warren Azultine in all capital letters?
Your Honor, I can speak with Mr. Azultine in a breakout room if you prefer, or...
Well, he's not represented by counsel and hasn't been throughout this case.
He's refused counsel.
Yeah. If you're Ty Azultine, just tell me that. If you're not, then I'm going to let you spectate for the rest of the court calendar until we're done.
I am the affiant of the affidavit of truth. And if you look at the affidavit, it will clarify who it is that I am. There are two.
Okay. All right. I've muted your microphone. It appears to me that you don't claim to be Ty Azultine, so I'm going to strike Ty Azultine's hearing, and the matter will be, the warrant will be left outstanding. And Heidi, no one is eligible to appear on Zoom in this case. They have to apply in person for a warrant quash. All right. And sir, you're free to remain and watch the rest of the calendar. We're going to go on to other people who are here.
Here's where the classic sovereign citizen strategy kicks in. Mr. Azultine launches into his I'm a living man declaration, a rehearsed monologue used by thousands of self-proclaimed freemen across America. The goal? To confuse the judge and avoid accountability by claiming the legal name in capital letters doesn't represent them. It's courtroom theater disguised as legal argument. But what's fascinating here is how calmly the judge handles it.
Calling case number 24 RO04189. This is people of the City of Royal Oak versus Anthony Winston Mathis. Mr. Mathis, are you available?
Yep.
Good morning.
Grand Rising.
You are Anthony Winston Mathis?
No, I'm Anthony Mathis, the living man, here in special appearance for Anthony Winston Mathis, also acting in my proper capacity of the
Mathis. Today's the date and time for your informal hearing. The citation before the court, Mr. Mathis, indicates that on May the 24th of this year at approximately 9 p.m., you are operating a 2024 Ford Edge, black in color on 11 Mile Road, air near Washington, in the city of Royal Oak. And at that place and time, you committed the civil infraction of impeding traffic. Impeding traffic, sir, is considered a lesser included offense within nearly any moving violation. And Officer Moran indicates in his detailed note that your vehicle was on East 11 Mile Road at Washington and disobeyed the traffic signal. The officer had a green arrow and therefore driver had a red light. Mr. Mathis, you have 3 options and 3 options only, sir, in the protection of your own rights. You may, sir, admit responsibility in this matter. The court will attach the scheduled fine and that will close the case. Or, Mr. Mathis, you may admit responsibility with an explanation that you believe mitigates these circumstances, or you have every right to deny responsibility and the court will swear the parties and will take testimony. What would you like the court to do for you today?
Well, I have a few questions, if you don't mind.
The court does mind. You need to make a plea. I am required by law.
No, I don't plead to anybody. I only plead to the Most High. Who are you?
I am Magistrate William Urick, P43273. I am a sworn judicial officer of this district. We are here for your informal hearing that you requested. This court is required by law, procedure, and court rule to take a plea. The motorist requesting this informal hearing, that being you, must make such a plea. You may admit responsibility in this matter.
I don't plead to anybody but God.
You may admit with an explanation, or you may deny responsibility, and the court will swear the parties and will take proofs. What would you have the court do for you today?
I don't plead to anybody.
Very
So
well. Officer Moran and Mr. Mathis, please raise your right hands.
I do have a question.
At this point, the judge makes a critical move. He refuses to engage with the theatrics. Sovereign citizens thrive when judges argue back. But here, the judge only demands one thing. Are you the defendant or not? This is Courtroom Control 101. The moment a judge loses that, the hearing collapses into chaos. But by drawing a firm line, identify yourself or sit as a spectator. He's preserving order while exposing how empty these affidavit of truth tactics really are. It's logical authority versus delusional defiance, and logic wins every time.
You solemnly swear the testimony you shall give before this court shall be the truth, so help you God.
I do.
Thank you very much. Please proceed.
Magistrate, on May 24, 2024, at approximately 9 p.m., I, Officer Moran, was in the area of East 11 Mile in Washington when I observed 2024 Ford Edge, black in color, with Michigan plate Edward John Lincoln 6501. I was at the light at East 11 in Washington when I had the green arrow to turn. That vehicle then proceeded through the light. As I looked up at the traffic light, that light was red for that driver.
Very well. And with respect to your selection of citation, you elected to simply issue a ticket for impeding traffic. Is that correct?
I did, Magistrate, at that time.
That's based on your discretion, your training, and your experience.
It is.
Thank you. You obviously have the right to rebuttal if you choose to use it, Officer Moran. Mr. Mathis, it is now your turn. What would you like the court to know, sir?
So I have a question. Are you a judge?
Mr. Mathis, the court has already indicated it is a sworn judicial officer. It is exercising its jurisdiction lawfully over you. So questioning the court's authority.
You don't have any jurisdiction over me. I would argue you don't have any jurisdiction. Okay.
Mr. Mathis, the officer has already testified as to the facts of the case. It is now your turn to testify. You can tell the court anything you wish the court to know, focusing solely on the events of the date in question. What would you like to tell the court?
The plaintiff is the city of Royal Oak. Please bring the city of Royal Oak. Where's the city of Royal Oak?
The officer is representing the city of Royal Oak, sir.
Where's the city of Royal Oak?
Are you asking where it is geographically, or are you asking where it is in
Right
terms
now.
of who's present on behalf of the city of Royal Oak?
And just like that, the first sovereign citizen bails. Quite literally. The irony? If he'd simply confirmed his name and apologized, his warrant would have been quashed on the spot. Instead, he leaves with an active warrant still hanging over his head. This is a paradox of sovereign citizen ideology. They reject the system, but end up trapped deeper inside it. It's self-sabotage dressed up as rebellion. The judge's restraint here is commendable. And honestly, if patience were a legal virtue, he'd be on the Supreme Court by now. Enter contestant number 2, Anthony Matthews, another self-proclaimed living man. His introduction alone tells you where this is going. I'm here in my proper capacity as trustee of the trust. Translation? He's about to challenge reality itself. What's so intriguing about these hearings is how similar the scripts are. They follow online templates from sovereign citizen forums, often copied word for word. It's a subculture of legal misunderstanding. People memorizing jargon to sound powerful while ignoring the actual law.
Please bring the.
Court doesn't understand your question. Are you asking where it is on a map or where is the officer?
No, I know exactly where it is on the geographic location, but where are they right now?
The officer is representing the city of Royal Oak as a sworn and certified Michigan peace officer. So what else would you like to tell the court, Mr. Mathis? And please, again, the court suggests that you focus on the events of the date in question.
Okay. Well, could you please bring forth the injured party? Was anybody injured?
This is not a tort case, Mr. Mathis. It is a case written
Well,
under the vehicle code of the city of Royal Oak as it is adopted.
As I was traveling, the officer turned on the lights. No one was injured. So please bring forth the injured party. Based on the Constitution, the Sixth Amendment right, I have a right to face my accuser. If the plaintiff cannot come to court, then this shall be dismissed. That's failure.
Mr. Mathis, is there anything else you wish the court to know?
Please bring forth the injured party. If you can't bring forth the injured party, then this needs to be dismissed now.
Mr. Mathis, is there anything else you wish the court to know?
You guys can't bring anyone forward as far as the injured party. No one was injured. You guys.
Mr. Mathis, I will ask you one more time. The officer is representing the city of Royal Oak. This is not a case alleging physical harm or breach of contract.
Why are you trying to charge me?
This is a civil case
under
the Motor Vehicle Code as it was decriminalized in 1979. This is a civil matter. The burden of proof is a preponderance of the evidence. The officer has testified as to what he observed, and it is now your turn to testify as to what occurred. There is no requirement under the rules of procedure, civil, in this operation as of today, that requires a quote unquote injured party to be present. The officer has stated very clearly and fairly and plainly what he observed that day. So as to your testimony related to the date in question, is there anything else you would like the court to know?
No, it isn't. If you guys can't bring any
Here's where things heat up. The magistrate lays out 3 clear options. Admit responsibility, admit with explanation, or deny responsibility. That's how every traffic hearing works. But Matthews refuses, saying he only pleads to the Most High. That's when you realize this isn't a misunderstanding. It's deliberate obstruction by refusing to enter a plea. He stalls the process and turns a 5-minute infraction hearing into a 20-minute circus. The magistrate, however, maintains composure, showing how judicial procedure can't be derailed by personal beliefs. This right here is sovereign citizen myth number 1. If there's no injured party, there's no crime. That argument applies to torts and criminal cases involving actual harm, not civil infractions like traffic tickets. Running a red light doesn't require a victim in a hospital bed. It's a public safety violation, not a personal one. The magistrate's response is textbook, calmly explaining the civil nature of the case while refusing to entertain pseudo-constitutional theatrics.
Thank you so much. Mr. Mathis, the burden of proof in a civil case is a mere preponderance of the evidence. The officer, a duly sworn and certified Michigan peace officer representing the city of Royal Oak, which is one of 2 cities upon which this court has jurisdiction, has put his testimony forward. There is nothing in the record that has rebutted any of it. Therefore, the court is finding you responsible for the citation as it was written. The fine for that serves $175. That is payable through the pay portal on the 44th District Court website or you may walk a cash check or charge into the
I will not be
44th
paying
District
any
Court.
fine.
Please don't interrupt the court, sir. You may walk a cash check or charge into the 44th District Court at 400 East 11 Mile Road, Monday through Friday, between 8:30 and 4:30. That's due within 7 days, Mr. Mathis. If you take exception to the court's ruling, you may post a bond in the amount of $175 within 7 days, and the matter will be placed upon the formal hearing docket of the Chief Judge of the District, and at that time, the City of Royal Oak would be represented by a city prosecutor. So either a bond or a fine of $175 payable within 7 days. That completes your hearing. Thank you.
And that's the end of it. The magistrate finds Matthews responsible, imposes the $175 fine, and exits the call before the nonsense can continue. Clean, professional, and perfectly handled. What's the takeaway here? Sovereign citizen arguments may sound bold online, but in a real courtroom, they crumble instantly under procedural law. The judge and magistrate in this video showcase restraint, clarity, and the power of calm authority.